Welcome. In this session, we will address one of the most critical intersections between law and medicine, informed consent. It is not just paperwork. Informed consent is not merely an administrative checkbox, nor is it just another formality within the medical record. It is a fundamental right of the patient and, simultaneously, an ethical and legal obligation for the healthcare professional. Why is it so relevant? Because it guarantees that the patient can make free decisions regarding their medical care, but only after receiving information that is sufficient, clear, and understandable. This strengthens trust within the doctor-patient relationship and helps prevent ethical legal conflicts that might otherwise arise during clinical practice. It is grounded in law. Furthermore, informed consent does not stem solely from a moral duty to inform. In Mexico, it is backed by specific regulations, such as the Regulation of the General Health Law regarding medical care services and NOM 004 for clinical records, among others, a bridge between ethics and law. This concept articulates bioethical principles, such as autonomy, non-maleficence, and justice, with legal requirements and quality of care standards, our roadmap. In this first session, we will focus on understanding its nature, its requirements, and its relationship with patient autonomy. In the following session, we will address exceptional cases, such as therapeutic privilege. To understand the importance of informed consent, we must start by defining it properly. Informed consent is a process of communication between healthcare personnel and the patient. It is not merely a signature on a document, but an ethical and legal act. In this act, the patient, after receiving clear, complete, and understandable information, makes a free and conscious decision regarding their medical care. In other words, consent must be voluntary, it must be based on sufficient information, and, when regulations so require, it must be documented in writing. Why is it so relevant? Because it implies recognizing the patient as a person with rights, capable of accepting or rejecting treatments, rather than as a passive recipient of medical decisions. Now, it is important to distinguish this from similar concepts. For example, there is implied, or tacit, consent. This occurs when a patient evidently cooperates with a simple procedure, such as extending their arm for a blood pressure reading. However, this type of consent is not valid for higher-risk procedures. We also have therapeutic privilege. We will address this in detail in the next session, but it refers to exceptional circumstances where a physician may temporarily defer or limit the information given to a patient if they believe revealing it immediately could cause serious harm. Finally, we must underscore that informed consent is strictly regulated in Mexico. For instance, the official standard NOM 004 SSA 3 2012 in its introduction clearly establishes that, within the framework of exercising patient rights, this standard ratifies the importance of the health authority guaranteeing the free expression of the patient's will to be treated or not through clinical or surgical procedures. To this end, health personnel must obtain their consent, following the provision of information and explanation of possible risks and expected benefits. Now that we understand what informed consent is, we must ask, when is it actually valid? It is not enough to simply have a signed piece of paper. For informed consent to be considered legally binding and ethically acceptable, it must meet a series of well-established requirements. First, the patient must possess the legal and mental capacity to decide. This implies being of legal age, or possessing sufficient maturity in the case of minors, and being in full command of their faculties. If this condition is not met, the consent of a legal guardian or representative becomes necessary. Second, the information provided must be clear, sufficient, and comprehensible. The physician is obligated to explain the diagnosis, treatment alternatives, expected benefits, involved risks, and the potential consequences of refusing treatment. All of this must be conveyed in accessible language, avoiding unnecessary medical jargon. Third, the decision must be voluntary. If the patient is being coerced or pressured by family members, authorities, or even by the physician themselves, that consent becomes invalid. Fourth, the physician must verify comprehension. It is not enough to simply recite information. One must foster a dialogue to ensure that the patient genuinely understands what has been explained, and to answer any questions. Finally, consent must be documented in the appropriate form. For simple procedures, verbal or implied consent may suffice. However, for high-risk procedures, it is mandatory that consent be recorded in writing, bearing the signature of the patient and, where applicable, witnesses. These are not arbitrary rules. All these requirements are codified in the Regulation of the General Health Law regarding medical care services, specifically in Articles 80 and 81. When a procedure involves significant risks, the law requires informed consent to be documented in writing. However, for this document to be valid, not just any format will do. Article 82 of the Regulation regarding the provision of health services clearly establishes the minimum elements that must be included. Pay close attention, as this information is fundamental for daily clinical practice. First, it must state the name of the institution to which the hospital belongs, as well as the specific name or legal entity of the establishment where the procedure will take place. Second, the document must have a clear title, for example, Informed Consent for Diagnostic Laparoscopy, Third, it must indicate the place and date where the consent is issued. Fourth, it must include the name and signature of the person granting consent, that is, the patient or their legal representative. Fifth, when applicable, the signatures of witnesses must also be included. Sixth, the authorized procedure or treatment must be described clearly, explaining exactly what it entails and why it is being proposed. Finally, the document must be signed by the treating physician, serving as proof that they provided the necessary information. Additionally, there is something we must not forget. The consent form must be written without abbreviations, cross-outs, or amendments. Furthermore, it must be drafted in language that is clear, understandable, and free of ambiguity. This document is not merely a file to satisfy a requirement. In the event of a complaint or lawsuit, it can represent the physician's primary legal defense, as well as proof of respect for the patient's rights. At the heart of informed consent lies one of its most critical ethical pillars, its relationship with patient autonomy. But what do we mean by autonomy in this context? It is the fundamental right of every person to make decisions regarding their own body, health, and life, based on adequate information. It means recognizing that the patient is not a passive subject, but an active agent possessing both the capacity and the right to choose. When we speak of informed consent, we are essentially describing the tool through which this autonomy is exercised. The physician informs, guides, and answers questions, but the final decision must always belong to the patient. Now, what happens if the patient's decision contradicts what the physician considers medically optimal? If that decision was informed, free, and conscious, it must be respected. This is demanded by both ethics and the legal framework. While there are specific exceptions we will cover later, this remains the general rule. However, there is a condition. For that decision to be valid, the information provided must be clear and comprehensible. If the patient does not understand what is being explained, they are not fully exercising their autonomy. Beyond mere legal compliance, this is a matter of respect for human dignity. When we recognize patient autonomy, we are practicing medicine that is more humane, more ethical, and truly person-centered. Let's illustrate this with an example. Imagine a patient who, for religious reasons, refuses a blood transfusion. Even if the transfusion is the most medically indicated option, provided the situation has been clearly explained and the refusal is voluntary, their decision must be respected. To truly grasp the depth of informed consent, we must link it to the principles of medical bioethics. These are the principles that guide every responsible clinical action. The first of these principles is naturally autonomy. As we have explained, the patient has the right to decide regarding their own body, and informed consent is the precise instrument that makes this possible. The second principle is beneficence. Healthcare professionals must always act in pursuit of the greatest benefit for the patient, proposing treatments or interventions that improve their health or quality of life. However, this benefit cannot be imposed. Therefore, the information provided must aim to promote well-being, yet always respect the patient's final decision. The third principle is non-maleficence. This translates into a simple yet powerful phrase: first, do no harm, primum non nocere. This principle demands that the physician warn of the risks associated with any intervention. If these risks are not explained, the consent cannot be considered informed. The fourth principle is justice. This implies treating all patients with equity. The right to receive clear information and to participate in decisions must never depend on educational level, socioeconomic status, or any other condition. These four principles are present in every single medical act. Let's look at an example. A doctor proposes a treatment. Beneficence explains the risks involved. Non-maleficence. The patient makes a choice. Autonomy. And the doctor ensures the information was understood regardless of the patient's background. Justice. Why is this important for you? Because these decisions do not only occur during complex interventions, they appear in everyday practice, when asking for permission to insert an IV line, when taking a lab sample, or even when prescribing a restrictive diet. So far, we have presented informed consent as a general rule in medical practice. But do exceptions exist? Are there situations where consent can be omitted or modified? The answer is yes, and they are clearly regulated under Mexican law. It is not a matter of ignoring consent, but of recognizing that there are exceptional cases where obtaining it beforehand is neither possible nor ethically enforceable. Let's look at three key situations. 1. Medical emergencies with life-threatening risk. When a patient arrives unconscious or unable to decide, and no family members or guardians are present, physicians must act. In these cases, at least 2 doctors must assess the case and make the decision, always leaving a clear record in the clinical file. This specific situation is regulated by Article 81 of the Medical Care Regulation. Second, patient incapacity. If the patient has a permanent disability or a temporary condition preventing them from deciding, consent is granted by their guardian, legal representative, or closest relative. However, even in these cases, if the patient possesses partial understanding, their opinion must be taken into account. 3. Therapeutic privilege. We introduce here the concept of therapeutic privilege. This principle allows the physician, in very specific situations, to temporarily withhold certain information if they believe its immediate revelation could cause serious harm to the patient. This is not about lying, it is about protecting the patient. It must be applied with extreme caution and always be documented. A crucial warning: these exceptions must never be used as an excuse to act without informing. They must be justified, clinically evaluated, and explicitly recorded. In summary, if informed consent is the rule, these are the carefully grounded and monitored exceptions. Up to this point, we have discussed informed consent as an ethical and legal process. But now, we must pause to consider a fundamental aspect: the proper documentation of that consent. We must ask ourselves, what is the use of a clear explanation if no record remains? How can we demonstrate that the patient was informed without written evidence? Documenting informed consent is not a mere bureaucratic formality. It is a key tool for the legal and clinical security of the Medical Act. If it is not recorded, in the event of a complaint or legal proceeding, there will be simply no way to prove that the obligation to inform was fulfilled. From a legal standpoint, signed consent is the physician's primary defense, but it is also a guarantee for the patient. It certifies that the decision was free and that necessary precautions were taken. From a clinical standpoint, documenting it correctly allows for case follow-up, facilitates information sharing with the healthcare team, and ensures that everyone involved understands the limits and scope of the authorized treatment. But what happens if the document is flawed? If a signature is missing, if it is incomplete, or if there are crossouts or ambiguities, the consent can be challenged. This puts the integrity of the entire care process at risk. Therefore, we must be careful. We must be diligent not only in what we say, but in how we record it. To document well is part of practicing medicine with quality and ethics. One of the most frequently asked questions is, when exactly must informed consent be documented in writing? The answer is clearly outlined in Article 80 of the Regulation regarding medical care services. It states that whenever a procedure implies significant diagnostic, therapeutic, or surgical risks, consent must be written and signed. This includes, for example, all types of surgical interventions, including ambulatory or minimally invasive ones. Procedures requiring general or regional anesthesia, such as a C-section or laparoscopic surgery. Invasive studies, such as endoscopies, biopsies, or catheterizations. Blood transfusions, which are particularly relevant when religious objections exist. Participation in research protocols, which requires even more specific and detailed consent. And procedures with special ethical or legal connotations, such as voluntary sterilization, legal termination of pregnancy, or organ donation. In all these cases, the document must include every minimum legal element we have already reviewed, and it must be filed within the clinical record. This requirement is non-negotiable. Non-compliance can lead to serious legal consequences for both the physician and the institution. Consider this scenario. You might have performed the procedure perfectly, strictly adhering to the lex artis, the standard of care. However, if the patient did not consent to the treatment, technical perfection does not matter. A fundamental right has been violated, and legal consequences will follow. Therefore, the rule is simple. Whether you are in a hospital, a private office, or any clinical setting, if you are facing one of these procedures, you must not proceed without having written informed consent, duly signed and documented. This is a measure of respect, mutual protection, and strict compliance with the law. With this final slide, I invite you to reflect on everything we have covered in this session. Informed consent is not merely a legal requirement, nor is it solely a clinical act. Above all, it is a concrete expression of how we conceive the practice of medicine itself. It represents a medicine that respects patient dignity, a medicine that listens, informs, engages in dialogue, and shares the responsibility for decisions. When we obtain informed consent properly, we act on 3 levels simultaneously. On the ethical level, we strengthen trust, autonomy, and respect for the individual. On the legal level, we protect ourselves and provide legal security to all parties involved. And on the professional level, we enhance the quality of the Medical Act, promoting care that is safer, more humane, and more responsible. Crucially, we must remember, consent is not just a document, it is a process of communication, of joint construction. The signature is not the beginning, it is the culmination of that process. The results speak for themselves. When this process is executed correctly, legal conflicts are reduced, decision-making improves, and satisfaction increases for both the patient and the healthcare team. To conclude, I leave you with a question. How would you like to be informed if you were the patient? That is the key. Informed consent must be viewed not as an administrative burden, but as a tool for respect, protection, and quality. Looking ahead, in our next session, we will address the complex cases, therapeutic privilege, and real-world situations where consent becomes a true dilemma.